This is Bloomberg Law with June Grasso from Bloomberg Radio.
Donald Trump failed to convince a judge to throw out his conviction in the New York hush money case on presidential immunity grounds. But the case is far from over as the president-elect continues to press other challenges to that verdict. Judge Juan Merchan rejected Trump's arguments that the trial was tainted by evidence that wouldn't have been allowed under a controversial Supreme Court decision in July that gives presidents broad immunity from criminal charges. Joining me is former federal prosecutor Robert Mintz, a partner at McCarter English. Bob, tell us about the decision.
The judge's ruling essentially rejected Donald Trump's argument that a recent Supreme Court ruling that created criminal immunity for former presidents required the dismissal or the overturning of the conviction in the New York case, and he upheld the former president's felony conviction for falsifying records to cover up a sex scandal.
People might be confused because the Supreme Court decision related to presidential actions while he was in office, but in this case, the actions occurred before he took office.
Yeah, that's exactly right. The Supreme Court decision that really forms the basis for this motion by the defense to dismiss the New York case was an immunity decision that came out of the special counsel's case in Washington, D.C., where Mr. Trump was accused of plotting to overthrow his 2020 election loss. It had nothing to do with the New York case. It was a 6-3 ruling that held that a former president was entitled to at least presumptive immunity from prosecution for all of his official acts. And that's really the key word here, official acts. So what the Trump defense team did is to say that although that Supreme Court case came about as a result of another prosecution, their argument was that it applied here as well. And essentially what they were arguing was that in light of the Supreme Court's immunity decision, prosecutors had improperly relied on certain evidence that they said involved official communications during his first term in the White House, and that therefore tainted the conviction and it had to be overturned.
Bob, some of that evidence, conversations, actually occurred in the Oval Office of the White House. So explain the judge's analysis in finding that these weren't official acts.
The defense argued that there were two pieces of evidence here that should not have been admitted during the trial. One focused on certain tweets that President Trump had been involved in that were used during the trial that the defense argued should have been excluded as official acts. Justice Merchan rejected that defense effort to portray the tweets as official acts, concluding that they do not constitute the type of conduct that the Supreme Court intended to protect in that decision. The other argument that the defense made, which was really a stronger argument and one I think that Justice Merchan gave more time to in considering, was the argument that certain testimony that was admitted during the trial, testimony that, according to the defense, was critical to the conviction, that should never have been permitted. And what it focused on was the testimony of two of Mr. Trump's former White House employees, his communications director, Hope Hicks, and Madeleine Westerhout, a director of Oval Office operations. The testimony that came in through the prosecution's case was when Ms. Hicks told the jury about a discussion she had with Mr. Trump in the White House after the hush money deal with Ms. Daniels came to light. Ms. Daniels was the former porn star who was allegedly paid off by Mr. Trump in order to keep that story from breaking during the 2016 campaign. The prosecution argued that the discussions between Ms. Hicks and Mr. Trump related to solely unofficial conduct and therefore didn't fall within the scope of the Supreme Court's decision. And that's exactly what the court ultimately decided. The court ruled that the evidence the prosecutors had used was decidedly personal acts and had to do with falsifying business records and was not the type of official conduct that the Supreme Court was getting at in that immunity decision because it posed no danger of intrusion on the authority and function of the executive branch.
So Judge Merchan was in completely uncharted waters here in applying that rather ambiguous Supreme Court decision on presidential immunity. What does that mean for the chances of reversal on appeal?
So let's keep in mind that Supreme Court decision, which was highly controversial in the eyes of some people, has never been actually applied in practice to a case below. This is the first time that any judge is trying to take the guidance from that immunity decision and apply it to an actual case. So it's certain that the Trump team is going to appeal this ruling first to the appeals court in New York, then to what is essentially the New York Supreme Court, which is called the Court of Appeals in New York. And then beyond that, they may take it to the U.S. Supreme Court. So it ultimately may wind up before the U.S. Supreme Court again, because the decision has never been tested before. And really, as you say, this is uncharted territory for any judge to apply this decision to an actual criminal case.
Judge Merchan engaged in 3 levels of analysis here, ending with the idea of harmless error. Sort of, even if I'm wrong about admitting the evidence, it's harmless error. It wouldn't have changed the verdict.
Yeah, so the judge did go through several layers of analysis here. First, he found that there were some technical issues that the Trump defense team had not raised this at the time of trial. One of the arguments was that they objected to Hope Hicks' testimony literally on the first day of trial, and it was too late to raise it. Another argument is that they did not preserve the objection during the course of the trial. But ultimately, that was not the basis on which the justice made his decision. He then looked to the core of the Supreme Court decision, which is, are these official acts or are they not official acts? Because the Supreme Court decision says there's presumptive immunity for official conduct, but they did not say that every act by a president while in office constitutes official conduct. And so he looked at that issue and ultimately determined that the conduct here that the defense was complaining about was not within the official scope of the president's authority as president, because it either involved conduct that predated his becoming president, or even after he became president, it was focused on issues that predated his becoming president. Then the judge further looked at the question of, even if it was admitted improperly, in other words, even if you were to concede that the testimony of Hope Hicks should not have been presented to the jury, the judge found it was something called harmless error, which means that in a case where there is an enormous amount of evidence, and there's one piece of evidence that the court would say perhaps was improvidently admitted and put before the jury, you don't have to throw the entire case out and retry it again if the judge concludes that it was what's called harmless error. In other words, there is an overwhelming abundance of evidence that the jury could have relied on for the conviction, and this additional piece of evidence was essentially surplusage. It wasn't necessary. The jury had more than an ample basis to reach the verdict that it did without considering the evidence that may have been improperly presented to them.
So, Bob, these motions flow sort of logically from that Supreme Court case. But Trump has also made a motion to throw out the case entirely due to his re-election, claiming he has categorical immunity from prosecution. These are all novel arguments. Of course, we've never had a president who's been elected despite having felony convictions. Tell us about his arguments.
Sure. So there is considerable deference that is given to presidents in order to make sure that there are not legal proceedings that interfere with their ability to carry out their official acts. Obviously, you don't want a president focusing on a criminal conviction or a criminal prosecution while they're in office. And so there's a lot of deference and there's a lot of law that says that a president should not be encumbered with these types of things while they're in office. And there's also some unwritten Department of Justice policies out there that says you don't indict a sitting president for the very same reason. So the Trump defense team is latching on to those types of decisions and those types of policies to say that this conviction really would interfere with President Trump's ability to serve his second term here. And they're asking that this New York case be unwinded. They're saying that the electoral victory really requires that this case be thrown out because it would interfere with his ability to carry out his duties as president of the United States. And one of the things that prosecutors have offered up here is the opportunity to simply stay this case and to await the sentencing until after President Trump is no longer in office. The Trump defense team has attacked that as well, saying that you could not have a president who is able to freely operate and make decisions if hanging over his head is the prospect that anything he does while in office may affect his criminal sentencing, which would come at the conclusion of his term.
On the other side of that, you have a jury verdict. So a jury came back and made this decision. Is the judge just going to toss that decision because Trump became president? It seems like a slap in the face of the justice system if he does that.
Well, and that's exactly what prosecutors are arguing. I think the Manhattan DA is sensitive to the unique circumstance in which they find themselves with this case having gone to jury, having reached a verdict in which jurors unanimously convicted former President Trump on 34 counts, but he has not yet been sentenced, and that sentencing was delayed by appeals and other issues. And now, of course, he's been reelected and will, a month from now, be sworn in as President of the United States. So the DA's office has to figure out what did they do about this sentencing. And there's a couple options that they put out there. One is they could hold the sentencing off until after he's completed his term. Another option would be they'll allow the sentencing to go forward, and Justice Merchan could sentence former President Trump to a term of probation, which would not involve incarceration that interfere with his ability to serve as president. And then another really novel idea that the DA threw out was to treat this case as they do in a situation in which a defendant goes to trial, is convicted, and subsequently dies before they are sentenced. In that case, the conviction is not vacated, but there's also no sentencing. And so it just stands as a conviction, but there's never a sentencing. And that's just the way the case ends. And Manhattan DA's office has thrown that out as an option also. I don't think that's likely to be taken up by the judge. I think the judge is likely to either, at the end of the day, proceed with the sentencing and sentence President Trump to probation. More likely, he may simply hold this sentencing off until after President Trump completes his term. But Justice Merchan still has to rule on a number of these other motions that the Trump defense team have filed with the court. And bear in mind, once again, that as to every one of these decisions made by Justice Merchan, they're all likely to be appealed, not only to the Court of Appeals in New York, but to the New York Supreme Court, and then perhaps ultimately to the United States Supreme Court. So all of these decisions will likely be held in abeyance for quite some time as they run through the appeals process.
It seems as if what the Trump defense team is trying to do is to get this going fast so that Trump doesn't go down in history as the first criminal felon to serve as president. And January 20th is quickly approaching. So not likely that this is all going to get done by then, is it?
No, I don't think we're going to see any finality to this before former President Trump is sworn in for his second term. It will really likely be held in abeyance, and the questions about whether this conviction will ultimately remain or not will not be answered for many months, if not years down the road.
So lots more decisions to come in this case. Thanks, Bob. That's Robert Mintz of McCarter English. Coming up, the controversy around Biden's commutations. This is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
It was the largest single-day act of clemency in modern history. President Joe Biden commuted the sentences of about 1,500 people who were released from prison and placed on home confinement during the pandemic, and pardoned 39 Americans convicted of nonviolent crimes. Here's White House Press Secretary Karine Jean-Pierre.
The Americans receiving relief today include a decorated military veteran, a nurse who has led response for a number of natural disasters.
However, she did not mention that included in the clemency grant was former Pennsylvania Judge Michael Conahan, who orchestrated the Kids for Cash scheme to send some 2,300 children to for-profit prisons on false charges in exchange for nearly $3 million in kickbacks. Pennsylvania Governor Josh Shapiro, a Democrat, condemned that clemency grant.
But I do feel strongly that President Biden got it absolutely wrong and created a lot of pain here in northeastern Pennsylvania. This was not only a black eye on the community, the Kids for Cash scandal, but it also affected families in really deep and profound and sad ways. Some children took their lives because of this. Families were torn apart.
Joining me is an expert in constitutional law, Harold Krent, a professor at the Chicago-Kent College of Law. Hal, tell us about the clemency grant generally.
President Biden, late in his administration, used his august power to grant pardons and clemency to the largest number of people who were ever given some kind of relief in one day. And there were 1,500 people who received clemency. What clemency is, it retains the fact of conviction in any kind of problems with convictions that follow one for life, right to vote in some states, right to hold office, etc. But it allows them to be free of any kind of, either jail time or other kind of oversight, such as probation, drug testing, etc. And he granted 1,500 people this blessing of clemency for those who had previously been released during COVID, but because of fear of overcrowding in prisons and the fact that they were nonviolent offenders. So it was an easy, objective way to reach out and show some people mercy who, again, had been determined previously were nonviolent and could be released without any kind of problems. So it was a handy way. It wiped the slate, clean for the most part for these individuals. But of course, it was somewhat controversial because even though these were nonviolent offenders, he didn't pick and choose amongst them. And so there were some pretty bad actors, let us say, who received the gift of clemency in that 1,500 total.
Right. So one of the clemencies was to a judge who helped orchestrate one of the worst judicial scandals in history, a scheme to send children to two-profit jails in exchange for kickbacks. And even the governor of Pennsylvania, a Democrat, said, I do feel strongly that President Biden got it absolutely wrong and created a lot of pain here in northeastern Pennsylvania. Another was a woman who was convicted of embezzling more than $53 million in taxpayer money, which was one of the largest thefts of public funds in Illinois state history. Shouldn't the Biden administration have excluded some of these people with egregious crimes?
Yeah, the question that should be raised is why didn't this happen all during the administration? So should have been more ordered, more carefully thought out. Rita Gronwell, who you just mentioned, was the controller in Dixon, Illinois, and she took $50 million from kids, in terms of the ability to educate them. And she returned some of it, but still owes, I think, at least $10 million at least is missing right now still. And of course, the Pennsylvania Kids for Cash scandal is terrible. And if he had done a case-by-case analysis of who deserved clemency, they presumably would not have received it. Clearly they're already out of jail, and they have demonstrated to some authorities that they aren't likely to commit offense again in the future. But do they really merit clemency, wiping off any kind of oversight they have from probation? That's the question. But he couldn't do that because he waited a long time. It wasn't his priority. And he wanted to do something towards the end of the administration. I don't think he's done. And so he just used bright line rules of whoever has been previously released as not a danger, he'll let them wipe off any more oversight from their books. So in some cases, they had 3 years of probation oversight, meaning meetings with probation officers, presumably drug testing, and all that now is forgiven for those individuals, including the ones that we just mentioned.
Before this, President Obama granted 330 commutations to nonviolent drug offenders, and that was the most granted in one day in U.S. history until now. Is he just trying to beat the record?
No, I think it's a recognition that better do something late, not perfect, than do nothing at all. And I agree with that. It's just too bad that this was not a priority at all, during his administration, and so he had to address this in more of a, kind of a ham-handed way because he didn't have the time to decide which of these 1,500 to grant and which not to.
So he's still considering, the White House said, he's still considering more pardons and commutations. And opponents of capital punishment have called on him to empty federal death row by commuting the inmates' sentences to life in prison, knowing that Donald Trump is going to, once he gets into office, start federal executions again, as he did in his first term.
Yeah, President Biden campaigned on a pledged that he was against the death penalty. So the question has arisen, and we've talked about it before, is why has he taken so long to decide whether to commute the sentences of those 40 individuals who are languishing on death row in federal prisons? Now, there's definitely some bad actors involved in those 40 individuals. There's no doubt about it, including the Boston Marathon Massacre mastermind. But the question is, if you don't believe in the death penalty as a moral basis, shouldn't you be commuting those sentences? And my guess is he will, but again, why take so long?
The focus has been for the last few months, I mean, since he lost the election, whether or not he is going to do preemptive pardons of people who might be targeted by the Justice Department under Trump. I mean, there are many people that Trump has said he's going to target, like Jack Smith and, Alvin Bragg, the people who prosecuted him. Some are saying that would set a bad precedent. But preemptive pardons are not unprecedented, are they?
So preemptive pardons are part of the president's playbook. Most famous is Gerald Ford's preemptive pardon for President Nixon after President Nixon resigned due to the Watergate scandal. And the way President Ford, wrote that was for preemptively pardon for any kind of illegal activities that he undertook as, President of the United States. So that is a precedent, which is, quite broad. And, of course, there was a bit of a preemptive pardon for his son, Hunter Biden, as well. The combined pardon for what was identified in the past, but also preemptively for any 10-year period or so of what he might be charged for. So it's accepted that president's power includes his preemptive power, and that really, is a terrible conflict for those who might be extended it, because if you think you've done no wrong, let's say you're a Jack Smith, do you know that if you take this get-out-of-jail-free card, it helps your family? You don't have to go through public disgrace of a trial and the costs and the pressures of it. But on the other hand, do you look a little guilty? And so that's what there's been a lot of discussions, I'm sure, in the inner circles of the White House and amongst these individuals who've been targeted by President Trump about what should happen. So it's not an easy trade-off. And I think if given a choice, some of those on President Trump's list would say, yes, I'll take the pardon just in case. It's just important for my family. And others would say, never, because I'm never going to look as if I did anything wrong or not. And it may be that one option is for President Biden just to extend the pardon to those who earlier had said they'll take it, because they don't want to run the risk of all the money, all the bad publicity.
Yeah, because some of them, it seems like, some of them would be protected from prosecution. For example, he's often mentioned Senator-elect Adam Schiff. But he'd be protected, wouldn't he, under the speech and debate clause? And federal and state prosecutors who are operating under the color of law would also be protected?
Yeah, I mean, most of these so-called Trump prosecutions of his opponents are fanciful because, it wouldn't be able to indict them even for a grand jury. And as you mentioned, there's a variety of immunities. Nancy Pelosi and Adam Schiff obviously have the immunity from being members of Congress in their investigations, and the executive officials, the prosecutors, have absolute immunity for their prosecutorial actions, such as Jack Smith, to some extent Merrick Garland as well. So it's really unlikely that President Trump would have any kind of success in prosecuting most of those he's already identified as targets. But, you never know. Maybe there's going to be a state prosecutor who's willing to do the president's bidding who isn't bound by the same kind of immunity doctrines. Or maybe it's just a matter of public humiliation that he's trying to wreck. But I think the chances of success on this political basis are few and far between.
But as you mentioned, even if you'll be successful ultimately because of the speech and debate clause or something else, you still have to go through what may be a humiliating process, which could take time to resolve.
And who's going to pay for the attorneys, right? It's not clear that individuals have any kind of ready access to free legal work to protect them. I mean, there should be some people who would volunteer their time to represent individuals, but to some extent, lawyers are going to need to be paid in order to raise these arguments to get out from under the shadow of some kind of indictment. So there are trade-offs, and Adam Smith already said he would reject a pardon. Whether that's true, who knows, but it's likely to be true. I'm sure Nancy Pelosi would reject it as well. But maybe others would say, hey, I want the protection.
Coming up next on the Bloomberg Law Show, Donald Trump says he'll grant some pardons as soon as he takes office. I'm June Grasso, and you're listening to Bloomberg. President Joe Biden is commuting the sentences of roughly 1,500 people who were released from prison and placed on home confinement during the coronavirus pandemic, and he's pardoning 39 Americans convicted of nonviolent crimes. Biden said he would be taking more steps in the weeks ahead and would continue to review clemency petitions. It's not clear whether he'll issue preemptive pardons for those that might be targeted by Donald Trump when he takes office. But those who receive the pardons would have to accept them. And some, like California Senator-elect Adam Schiff, who was part of the House committee that investigated the January 6th insurrection, said such a pardon would be unnecessary.
I think it's unnecessary. But second, the precedent of giving blanket pardons, preemptive blanket pardons, on the way out of an administration, I think is a precedent we don't want to set.
I've been talking to Harold Krent, a professor at the Chicago-Kent College of Law. So, Hal, as you heard, some say that it would set a precedent, a bad precedent, if Biden issues these preemptive pardons on his way out of office, that Trump might replicate that when he leaves office.
Well, I mean, the door's already opened, right? I mean, I don't think there's any kind of issue about that. I mean, we know that Hunter Biden received it. We know that President Clinton's half-brother received a pardon. So the precedents are there. It's just the question is there political will for the president to continue to use the pardon in that kind of fashion for political reasons? But, there may be, again, good reasons to protect people who were loyal to the administration and say that, as a going away present, and so this is a promise to loyal members of the administration that you don't have anything to worry about in terms of vengeance. And the vengeance, isn't speculative. I mean, President Trump on numerous occasions has said, I want to make this a priority of my administration. So I don't think it's frivolous, even though I think most of these indictments will be frivolous. But nonetheless, it costs time and money to fight against it. Some are willing, some aren't.
So you mentioned Hunter Biden's pardon. And even when the White House press secretary was announcing these recent clemency, there were questions still about the president's decision to pardon his son Hunter. And it seems like, in the history books, when they talk about his administration and pardon, the first thing they may say is he pardoned his son, Hunter Biden, just like you hear about Bill Clinton pardon his brother. And the press secretary defended Biden's pardon of his son by referring to the letter that he wrote, saying that Hunter Biden was singled out because he was my son and raw politics entered into the process. But what did you think about the blanket nature of that pardon over, a 10-year period, whatever he's done over a 10-year period, whether it's been charged yet or not?
To me, it seemed like there was some concern by President Biden that his son may have done something else, right? That's the implication that one can draw from that. He's not just being pardoned for what he was charged with, the tax evasion or the drug use. I mean, he may have been charged with other crimes, and I think that's what it sounds like to the average observer. And the President Biden wanted to take the step and make sure that the Trump administration did not look for other kinds of misbehavior, misconduct by Hunter Biden, and they probably would have. So I think it's his decision to protect his son, but it does look to, again, an ignorant observer that there was something to hide, something to protect. And we may find out about it later, we may not.
On his last day in office, Bill Clinton pardoned Mark Rich, this fugitive financier who'd made deals with shady international regimes. He was on the FBI's 10 most wanted list. And Clinton has since said he regrets the pardon. I mean, do you think that no matter what good he does with clemency petitions or pardons, the first thing that comes up in the history books is going to be he pardoned his son when he said he wouldn't? Exactly.
I mean, there are two things about it. I mean, first of all, he said he wouldn't pardon his son and then did it, which, again, looks bad in terms of history. But the second thing that my reaction is he seems to be blaming his own Justice Department for a politicized prosecution of Hunter. That doesn't go down well with me at all, in the sense that he's sort of abandoning those that he, in fact, has empowered to make those decisions. So I think for that reason as well, the pardon of Hunter Biden is going to sit uneasily with many people. Again, the change of mind and the fact that he blamed his own Justice Department for a politicized prosecution.
Some have actually suggested, and one being Pennsylvania Democratic Senator Fetterman, that Biden should pardon Trump before he leaves office. Does that make any sense to you?
It could make sense. I think the time has passed for when he should have offered that to now President Trump. I think it would have been a kind of gesture, if you will, about bringing the very politicized halves of our country together. President Trump may well have said no. And, of course, the pardon would not have extended to the Georgia and New York cases. But because the likelihood was so little now of continued prosecution in 4 years, it probably would have been an easy thing for President Biden to do. I think with each successive week, it's less likely that he'll use that power to offer President Trump a pardon.
So now let's turn to Trump for a minute, because he said in an interview published with Time magazine, he said that within minutes or hours of taking office, he would pardon people convicted of crimes related to the January 6th attack. And Trump has been saying versions of that for years. What kind of a message would that send?
Well, he has said that consistently, but he's been inconsistent with respect to whether to offer pardon to all January 6th sort of insurgents, if you will, protesters, or just those who were nonviolent. You know, I can understand the pardon for the nonviolent trespassers, if you will, into the Capitol. But I think with those who actually attacked officers, whether they were Capitol officers or D.C. police officers, you know, I think that would send a terrible signal that you can attack a police officer and the president's going to get out of jail card free.
Through early December, the Biden administration received nearly 12,000 petitions for clemency and more than 1,400 petitions for pardons. So do you think that we'll hear more pardons or grants of clemency before he leaves office?
I'm convinced we will, but it's not going to be this wholesale nature as the most recent list of clemency petitions in particular revealed. I think there'll be more targeted individuals, case-by-case basis, those whose pardon applications may have been pending for several years now. So we'll see more, and I'm still guessing that we'll see commutations for those on death row, which are obviously everybody is concerned about, but time will tell. Now, the one thing President Biden could do in some of these last cases is also attach conditions to some of these clemency or pardons. We know from the past that the Supreme Court has upheld the use of conditions on pardons, so perhaps some of the offenders can be commuted on the ground that they do consider to have drug testing every X number of months, or some other offenders might be pardoned completely as long as they don't engage in certain kinds of, you know, such as the controller of the Dixon School District that we talked to. Maybe a condition on her clemency should have been that she never work as a controller or accountant again. So we might see some individualized uses of the clemency power to attach a condition to protect the public a little more than he has so far. But we'll have to see that. That'll only be on a case-by-case basis if we need extra protections, but he still wants to protect the individual from either staying in jail or from being on continued probation for 3, 4, 5 more years, as many were in the recent 1,500 acts of clemency that he offered.
Sure, we're going to be hearing a lot more about this in the month to come. Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.